But 8:30 being the time now, time for the Law Report with Damien Carrick. Good morning, Damien.
Good morning, James.
Last week's federal court decision against columnist Andrew Dodd certainly ignited an enormous debate on the issue of freedom of speech.
It certainly has. Last week the federal court ruled that 2 articles by journalist Andrew Dodd, published in the Herald Sun newspaper, breached the Federal Racial Discrimination Act. So was Justice Bromberg's decision a slap in the face for freedom of expression, or a measured response to an offensive racial slur? The Bolt decision has ignited passionate discussions all around the country, including right here in the corridors of your Radio National. Over the last few days, I've been part of a number of conversations centring around the federal court decision. One such conversation was with journalist Andrew Dodd, a former presenter of the Media Report program and a regular freelance contributor to many programs, including the Law Report. Andrew is currently a senior lecturer at the School of Journalism at Swinburne University.
I have described this as a slap in the face for freedom of expression because I think that despite the fact that the federal court would like us to look at this as being really a judgment on journalistic standards, or the lack of standards, by Andrew Bolt in these pieces, I think it is going to be perceived as being an attack on freedom of speech because I think it does curtail the extent to which we are able to talk freely about issues that are difficult to discuss, which may have a public interest component and which concern minority groups.
Why do you say that?
Because what this judgment shows is that the Racial Discrimination Act is about more than just trying to prevent racial hatred. You know, if you look at Alan Jones in Sydney on Talkback Radio, there was a case of somebody inciting racial hatred which led to the Cronulla riots. Here what we've seen is the Racial Discrimination Act being interpreted in such a way as upholding the need for racial tolerance. And of course this is something we all want to see. We all value racial tolerance in a pluralist and multicultural society. But it's then saying that journalism, albeit a sloppy piece of journalism, is preventing racial tolerance, therefore it's against the law. So what I'm saying is that I think that's just a little bit too heavy a sanction against a piece of journalism.
So you're saying that there's a spectrum, that there would be journalism which constitutes intolerance, causing offence and humiliation, but this doesn't quite get us there? What are you suggesting?
That is exactly what I'm saying. I don't think this quite crosses the line. You know, Alan Jones on Talkback Radio in Sydney crossed the line. I don't think here he's gone quite far enough for it to be subject to a sanction like this legally.
My understanding is that Section 18 of the Racial Discrimination Act, that the test there is whether the publication causes offence or humiliation. For you, that's not high enough a bar?
Well, I think it's an interesting bar, and it's certainly one that you can follow the logic for. You know, what Justice Bromberg is saying here is that this minority group, in a sense, gets to be the arbiter of what is offensive. And for them, as fair-skinned Aboriginal people, what Bolt has said is offensive. But the question is this: in a society where we want to encourage discussion about difficult issues, should we be enshrining a law that says that you have a right not to be offended? And I think the problem is that a lot of good journalism, not that I'm putting Bolt stuff in that category, this was not good journalism, it was lousy journalism, but a lot of good journalism does go about offending people by definition, because if you're going to write critical and honest stuff, people get offended.
Give me some examples.
Well, there would be lots of instances where we're talking about minority groups or religious groups where we're going to write stuff that really questions their practices. You know, if we're talking about Scientologists or the Exclusive Brethren or a Muslim group or any one of a number of minorities, we're going to be saying things about them that they're not going to like hearing. Now, have they got grounds under the Racial Discrimination Act to say, you know what, I've been offended by what you wrote, I'm going to take an action against you under the Racial Discrimination Act, and this ruling might just help me? I don't know whether that's really healthy. I wonder whether we shouldn't be a bit more robust at talking about this difficult stuff.
So what test would you like to see?
Well, I think it's fair enough that the Racial Discrimination Act should be about creating racial harmony and tolerance. I would take it a little closer to the spectrum, though, of something that incites racial hatred as being the point at which you say it's illegal. Now, where exactly you draw it up on the spectrum, I haven't sat down and thought through the nuances of, but I don't think this one went quite far enough.
Let me just take you to paragraph 423 of Justice Bromberg's reasons. the intrusion into freedom of expression is, talking about this case and his ruling, the intrusion into freedom of expression is of no greater magnitude than that which would have been imposed by the law of defamation if the conduct in question and its impact upon the reputations of many of the identified individuals had been tested against compliance with that law. In other words, if they'd run a defamation case, the outcomes would have been no greater in terms of restrictions of free speech. I think that's what he's saying there. Why be concerned about the Racial Discrimination Act and its impact on freedom of expression when we've got these laws which have been with us for ad infinitum, these defamation laws? So it's not a slap in the face for freedom of speech.
I think it is, because I think what it is enshrining is this idea that it is difficult under the law to offend people, and to offend people even at times when you're doing it legitimately. That's the extent to which I'm worried about these laws, the extent to which this will have a carry-on effect so that people who are doing legitimate kinds of journalism but offend people, whether they are now subject to the Racial Discrimination Act.
And the kind of journalism you're talking about might not fall foul of our defamation laws, but might fall foul of these laws or these established principles.
Exactly. So what I'm saying there is you could write something, you offend a particular group, you haven't in the process necessarily defamed them under the definitions of the Defamation Act, or you have the defence of honest opinion. What I'm worried about is whether the Racial Discrimination Act could catch you when the Defamation Act wouldn't.
Former Radio National journalist and academic Andrew Dodd.